May I read the verse? Notwithstanding anything contained in this constitution, no existing law in force in the state of Jammu and Kashmir, and no law hereafter enacted by the legislature of the state, defining the class of persons who are or shall be permanent residents of the state of Jammu and Kashmir, or conferring on such permanent residents any special rights and privileges, or imposing any other persons any restrictions as respects employment under the state government, acquisition of immovable property in the state, settlement in the state, or rights to scholarship or such other forms of aid as the state government may provide, shall be void on the ground that it is inconsistent with or takes away or abridges rights conferred on the other citizens of India by any provision of this part. Now, 31B, my lords, under the constitution provides that anything included in the 9th schedule shall be immune from challenge on grounds of violation of part 3.
Guru, now I also note that in your written submissions, you have really highlighted, what was the anomalies and what has been restored now.
Exactly.
The rights perspective.
That's right.
I think let's go into the
next. Three more things, my lords. I'll take only 3-4 minutes, my lords. Now, 31B in COILO, my lords, very extensively referred to the foundational value of the fundamental rights. Golden triangle of 14, 19, and 21. I've given all those paras in my submissions, my lords. In fact, I've given the extracts of all those paragraphs in COILO. Now, ultimately, my lord said, you cannot take away judicial review and any law included in the 9th schedule can be tested on the anvil of basic structure. Now, surely you cannot have a position, and that's what petitioners are bargaining for. What was there in the original constitution, my lords, this is the approach of this honorable court. The petitioners can't bargain for a position where the Jammu and Kashmir constitution, which is admittedly inferior in terms of, my lords, the constitutional governing instrument than the Constitution of India. They have something better than that. This is the kind of importance which has been given under the constitutional scheme of India. In fact, 31B itself, my lords said at one part in paragraph 78, just make a note of it, the validity of 31B was not in challenge, and therefore my lords did not go into it. My lords assumed that in Shankari Prasad and in Sajjan Singh it was upheld, therefore my lords didn't go into it. But instead, judicial review cannot be excluded. And you cannot say, by placing it there, I'm making it immune to challenge. That's precisely what 35A purports to do. That's the second part, my lords. Third part. Ultimately, my lords, all the nuts and bolts and the nitty-gritty looked at. What does it come down to, my lords? The basic structure is the gun norm. That's the touchstone on which any constitutional decision making has to be considered. The validity of any constitutional decision making has to be seen. Today, what are they, my lords, arguing in terms of basic structure? At the highest, apart from, if I may say so, diffuse arguments of fraud on constitution. Two square features which they want to invoke, my lords, in various forms. One is federalism. The other is, my lords, representative government. So far as representative government is concerned, I think that already the solicitor has pointed out, it's a Puducherry model, there is representation. So far as federalism is concerned, the highest that they are able to put it on is some kind of a derivative form of federalism based on what my lords have said in the 2023 NCT judgment. That's the highest they want to put it at, where they say that my lords are referred to an asymmetric federalism. Paragraphs 40 and 41 of 2023, my lords have been given, the citation is there in my notes of submissions. What they want to say now is, asymmetric federalism has been recognized. Now please stretch this and say the multisymmetric federalism of 370 should also be taken to be a basic feature of the facet of federalism. That's the argument. I'll give the page numbers of Dr. Dhawan's arguments. Page 280, page 211, volume 1 of submissions. After extracting from my lord's decision in NCT in 2023, they say that this now has to be stretched further to say multi-symmetric federalism. There, para 40 and 41 of 2023 at the risk of carrying coal to Newcastle, my lords. My lords, interestingly, have referred to 371 and all those provisions for various states by way of special provisions. My lords, there refer to how they are special provisions in 371. And it is on that basis, by relying on the marginal note. My lords have pointed out how constitutionally
some kind of asymmetric arrangement has been made. So it is on the basis that it is a special provision in 371. Today, what they want to do is equate 370, which is temporary, with 371 special provision. I hope I make myself clear.
Yes, yes.
Therefore, that is why I said it's a derivative argument they want to make. 371, my lords, consciously referred to the marginal notes and said how these are special provisions, and that's how they provide for special provisions. That cannot be stretched, my lords, to say that it has to be applied to 370. The temporary character, nuts and bolts of 370, all of them have been argued, my lords. I don't want to take the time anymore. I'm adopting those arguments. In the light of that, my lords, I would respectfully submit. In fact, the impugned COs are reflective of transformative constitutionalism. What was argued by Dr. Dhawan, in my respectful submission, the boot lies on the other foot. The impugned COs ensure that the Constitution of India, with all its plenary scope, applies to the state. In my respectful submission, my lords, the challenge of the petitioners is really a contradiction in terms. Because this is a case where the application of the Constitution of India, the plenary document, is sought to be challenged. The effect of the COs is to ensure that the entire Constitution applies to the state, with all Part 3 rights, with all the other provisions. Even on federalism, lords, there is one other portion in the opening remarks of Dr. Ambedkar while placing the draft constitution, lords, before the assembly, constituent assembly. I've extracted. No, there is another portion apart from what Mr. Giri read. So I've extracted that in my submissions. My lords could have a look at that. Therefore, my lords, in sum and substance.
Thank you, Mr.
In sum and substance, my lords, this is for perpetuation of vested rights. And the COs, my lords, make provision for realization of rights under the Constitution. I'm obliged.
Thank you, Mr.
Yes.
Who are you appearing for?
I am for the writ petitioner who had filed the writ petition in January 2018 against the effacement of all articles in respect of me in relation to Jammu and Kashmir. Part 3, effacement of Part 3, a core value from the Part 3. I challenged that before this output, and that has been tagged down. Enough has been argued, but I am arguing for class, that's Radhika Gill versus Union of India.
Which is that?
Radhika Gill versus Union of India, and my synopsis is at page, the compilation is 426. I take only 2 bits, my lord. This Radhika Gill and the other person belongs to that class who are descendants to those persons who have been lifted from Gurdaspur to Jammu and Kashmir in 1957 to handle the sanitation problem which had arisen on account of the long strike in Jammu and Kashmir. So they were settled in the outskirts of Jammu and Kashmir, and my lord, that now has converted now with the passage of time. Those are the slums, no property rights, etc., no education rights, etc. Now, my lord, your lordship may kindly see my prayer. The whole effacement of Part 3 in relation to Jammu and Kashmir, I have challenged in my writ petition. Your lordship may kindly see the Solicitor General referred to Article 14 effacement also. Your lordship may kindly see 35A Clause A. What exactly it does? It does one thing, my lord, delegating the power to the state legislature to define the permanent resident and not challengeable. That's what, my lord, the delegation has been done to the state government. State legislature, my lord, in this class, my lordship, defining the class of permanent resident and delegating it to state legislature and not challengeable. So, my lord, your lordship have not allowed such a delegation to the state government so far as the Part 3 aspect is concerned. So, that's what the solicitor said, that core value of Article 14 has also been taken away. And with the aid and assistance of this delegation, Section 6 was incorporated, and this is nothing but a homage to defined ancestry and none else. whosoever is there on a particular cut-off date, I was there in 57 only, my lord. So my predecessors were in 57 and we were there, and now we are denied. I am born there, and at least no fundamental rights are available to. That's why I challenge that right to education. Right, Section 6 has also been challenged in that petition. Now, your lordship, I am now, so far as my synopsis is concerned, paragraph 17 and subparagraphs have dealt with three aspects. One is the powers are precedent are constant in nature. The lordship may kindly see paragraph 7, subparagraph B.
That's been argued. That's been
Now, one thing. Relationship between 368 and Article 37.
That's been also argued. Yes.
No, yes, I have taken this. I have taken this here in that.
Thank you.
Thank you. Anything else? Yes. Yes. What about you?
I am appearing in I number 153121.
I number
153121.
15153.
153121 of 2019. That's Roots in Kashmir. Roots in Kashmir is an organization which is espousing the cause of Kashmiri migrants, now called displaced persons, since 1989. There are 5 lakh people. That's one petition. Number 2 is Dr. Charu Wali Khanna, that's a substantive writ petition in 2017, 369. That is, just give me number. What's the number? 396 of 2017. Submission is, I am given detailed written submission, that are conjoined written submission,
Page,
volume 3, page 444 to 456. And for convenience, I have filed a small note, 3-page note, which was taken on record, I read it.
We'll have a look at it, but you can just sort of in 1 minute just highlight what is the central point.
I'll say, the instrument accession dated 26/10/1947 is final, and issue of proclamation and the Article 1 and is completely applicable, so it has it's being an integral part of the India, domain of India. Then, I say,
something which has not been argued.
It's not. I say, with respect to the Article 370, which has been raised, herein, that the devolution of power of Constituent Assembly is transferred to the Legislative Assembly, as there is no Constituent Assembly as on 57. Therefore, it's not the.
That has already been argued so many times.
It's not. Concurrence given to the government of the state, but also repository. Ratification has been done to the Parliament. So, absolute majority, Parliament has rectified the decision. One is that. 2 is, and it's not a basic structure, as held in. I am going to.
Got the point.
I have relied in my. I relied on my 1973 for SEC volume 15 in Keshavananda Bharati of Justice Khanna. He has given that one. And then Bomai also, it's not a federal, it's a quasi-federal state. Then Puran Lal Lakhanpal and
that is now being covered.
Modification.
I had one judgment, because I could hold that. That is S. Sant Singh and others versus State of Jammu and Kashmir, reported in 1959, Jammu and Kashmir, page 35. That's a full-page judgment, which deals with modification clause of Article 30, Article J&K Tenancy Act. That is AR 1959, Jammu and Kashmir, page 35. Dealing with the challenge to provisions of Jammu and Kashmir Tenancy Act inserted in 9th schedule was upheld and did not violate any of the fundamental rights conferred of Article Part 3. See, this is then Coelho has said that it's not a fundamental, it's not a violation of fundamental rights under Article Para 102. Coelho is that page.
Coelho has been argued so many times. Everybody has referred to Coelho.
Then. We have very less time, that's why I'm just going to all these things.
So, Mr. Dwivedi.
Indra Sani, 35A, I have challenged a substantive writ petition, in 2017, which a notice was issued, and this was referred to the Constitution Bench in that time only. Then it was tagged along with this. So I have 4 judgments to cite on Indra Sani, that's equality.
19. Well, what has happened in this? Well,
You put it in your note.
I said, well, 27 and 32 notification.
We have 3 minutes now. Let's hear some other
I'll
people.
take 3
otherwise
minutes. I'll take 3 minutes. No,
Let's-
3 minutes. I'll take 2 minutes. I'll take 2 minutes.
No, no.
27.
Yeah, we have to close at.
Well, 27 and
Yes,
30.
Mr. Banerjee, what do you
I'll
have
say,
to
well,
say?
I'll say why.
Malad, I am
We'll read your written submissions.
One. Then one. Then.
I am appearing in IA 146764, my lords.
Just petition from 20.
No, that absolutely not. You have to conclude. We have to conclude by lunch. I mean, we had made that clear yesterday.
My 1 minute they'll take, my lord. I'll see him, Lord. I'll see him.
Mr. Judge, we are- we had said that, look, we are going to conclude at 1 o'clock. We had requested everybody to so structure their arguments that the others who follow have time. We are not going to cross 1 minute after 1 o'clock for
Yes,
this
my
side.
lord. I'll read the affidavit, my lord. I'll read the affidavit, my lord, which I mentioned in the morning, my lord. My lord.
We can argue for the next 3 minutes, but you know what the consequences. We are rising at the stroke of
My
light.
lord, I read. My lord,
We are starting with the
let me read the affidavit.
See, this is not fair. You said
This is
I will give my
filibuster.
half an hour to Mr. Dwivedi.
My lord, half an hour to me, my lord. I could curtail my half.
Mr. Judge, you
Half an hour.
specifically said
Gave your half an hour to.
My lord, can I read
that I'm
affidavit?
giving my half an hour to Mr. Dwivedi.
My lord, can I read my affidavit, my lord?
No, we'll read it. What is
Read it, my lord.
We are rising at 1 o'clock.
In my affidavit, my lord, I am making only one submission, my lord.
The
Let
element
Mr.
of
Lone
civic
take a
consciousness
statement for
must also
affidavit
apply
that
to
effect
legal arguments
that
as
he is a citizen of India and he doesn't, my lord, support terrorist states, my lord. Let him put an affidavit, my lord. Mr. Sibbal, Learned Counsel is here, my lord.
All right, 1 second. Just 1 second now. Just 1 second.
Please. Mr. Agarwal, what point do you want to make? Just formulate it, come.
My lord, affidavit, my lord.
My lord, only one thing, my lord. My lord, Mr.
Please, time is up. Your time is over.
President of the bar is
Your
here, my lord.
time is-
Jammu Kashmir President. My
Your
lord,
time is over.
My lord, I was appearing for Jammu and Kashmir High Court Bar Association. My lord, President of the bar is here, my lord. He wants to say something. That's all, my lord. I am curtailing my argument.
We are in charge of whom we will hear. You are not in charge of who will follow you.
My lord, I don't.
Mr. Kanu Agarwal.
Okay.
That's, my lord, I leave it to all.
Diversity, Dr. Dhawan sought to rely on the judgment of R.C. Podial. If my lord sees, to my understanding, federal diversity in the Indian Constitution exists on a two-dimensional plane. At the center would, as far as I understand, would be the classical states, would be the classical understanding of a state, the state which has fully governed by Schedule 7 and other provisions of the Constitution. To the right of it would be states which have limited special features, would be states like the limited features like Gujarat or Maharashtra, all taken through by Dr. Dhawan. Thereafter would be states which say fall under the 5th schedule and the 6th schedule, and some other states which have further special features.
To the right end of it, perhaps, was the erstwhile Article 370. What the petitioners forget, my lords, is that there is a scale to the left of it as well. The scale to the left of it is the union territories with legislature, is the union territory of the GNCT of Delhi, and further, perhaps, pure and simple union territories. Therefore, federal diversity, my lords, it's undoubted that diversity is a constitutional fact, but not all constitutional facts can be elevated to the level of basic structure. When we adopt the identity test in terms of identification of basic structure, not all constitutional facts become basic structures. R.C. Podial was relied upon to further the argument that this diversity, a manifestation of which was Article 370, erstwhile Article 370, is a part of basic structure. Incidentally, my lords, para 128 was read in R.C. Podial. If my lord sees the last 3 lines of para 128, I think that those last 3 lines itself completely demolish the case of the petitioners on federal diversity, because those last 3 lines itself indicate that these provisions which were in consideration in R.C. Podial were for a limited transitional period. The word transitional has been used.
Therefore, my lords, as far as the fact that federal diversity may be integral, it would not necessarily lead to it being a basic structure. The method and the methodology adopted by the union, whether under 368 or 373, has been fully taken care of. I don't wish to address it further. The second point is on, my lords, Constituent Assembly and the nature and the nomenclature of Constituent Assembly. Mr. Gopal Subramaniam specifically highlighted that
There are no hierarchies. That was his submission, that there are no. At a normative level, that's an absolutely correct statement. There cannot be any hierarchies in Constituent Assembly. However, there are not many things that move on a normative level in Jammu and Kashmir. There are three facts in this regard that my lords need to see. There are two kinds of constituent power. One is original constituent power, and the other could be derivative constituent power. It was on this jurisprudential basis that Keshwanand Bharti was delivered and thereafter other judgments, which state that the original constituent power is always with the original Constituent Assembly, the plenary power. But derivative constituent power is something that is always with further legislatures, the parliament in this case. Therefore, the question that we need to interrogate is whether the Constituent Assembly of the Jammu and Kashmir Constituent Assembly had any original constituent power. The three facts, which according to me clearly point towards the fact that they had no original constituent power, were A, it was established under the proclamation of a Maharaja that had already signed an instrument of accession. Number two,
Just one second.
it's there in the 3 page.
Yes.
Number two,
Maharaja had already issued a proclamation dated 25/11/1949, recognizing the supremacy of the Indian Constitution. And number three, unequivocally, Article 1 was in force. So on the date in 1951, when the proclamation to establish the Constituent Assembly of Jammu and Kashmir was issued, the Maharaja, who was not a sovereign, could not have passed a better title than what he had. If he was not a sovereign, the Constituent Assembly of Jammu and Kashmir could never have been a sovereign Constituent Assembly, could never have established a sovereign constitution. The suggestion from the other side is that under 370 sub-article 3, they could have severed their ties with India at the time of dissolution of the Constituent Assembly. My lords, I submit that is an absolute impossibility as far as the Indian Constitution is concerned, because Article 1 would have applied to them irrespective of the nature of Article 370.
Which is the page of your written submission? In the
that's page 2.
No, in the volume 3.
My lords, that is not there in volume 3.
I have kept those.
My lords, if my lords allow,
All right, thank you.
please, my lords. Just one more aspect, my lords.
Yes.
If the J&K Constituent Assembly had no original constituent powers, it automatically exercised only derivative constituent powers. If it is exercising derivative constituent powers, it is akin to a legislative assembly. My lords, one of the letters that was highlighted by Mr. Shankar Narayan was a letter by Rajendra Prasad to Mr. Nehru. My lords may remember 1952, 6th of September, I think, 1952 by Rajendra Prasad. That letter finds mention in Mr. Noorani's book at volume 20, page PDF 222, I believe. Mr. Noorani has done a lot of research. He should have also pulled out the letter which was written by the then Prime Minister, Mr. Nehru, in reply to the letter of Rajendra Prasad. Mr. Nehru wrote a letter dated 7/11/1952 to Mr. Rajendra Prasad on a host of issues, after Mr. Rajendra Prasad had also written a letter to the then Home Minister K.M. Munshi. And he highlighted the fact that how this issue has been discussed with the law officers of the union at the highest level, with Mr. Gopalaswamy Iyengar and with other people. I have annexed it to my note, my lords. And therefore requested the president, requested the president to consider passing the CO. That was on 7th of November 1952. Within 8 days, my lords, the learned president passed the CO 44, which was 15/11/1952 under 373, thereby changing Maharaja to Sadar Riyasat. Therefore, my lords, I think the SG had also pointed it out that actions speak louder than words. That is all that I have.
Yes, Mr. Vikram.
My lords, I'll just make a small submission. My lords, my submission is this. My lords have seen the original constitution. The original constitution.
Biju, move towards the center.
Yes. My lords, the original constitution, there were transitional and temporary provisions It wasn't, the special provision was subsequently added as an amendment at a later point of time. So the original constitution in this chapter was as to temporary and transitional provisions. So the very fact that this is taken to be a transitional and temporary provision means that this is the entire objective of the original part. Subsequently, a large part of it, my lords will recall, has from 75 to 91 have now been amended out. So the original intention of including 370 in that chapter, and it was in the genus of that, was this was a transitional provision. And my lords will see 391 and 392, there were presidential powers which were given to make amendments.
Thank you, Mr. Banerjee.
My only submission is this was permissible to
This has been
follow.
already argued, Mr. Banerjee.
Thank you, Mr. Banerjee. Now, Ms. Pathak, come along, come forward. 1 second. We'll call out. We are calling out people. Don't jump the gun. Yes.
1 minute, my lord.
1 second, Biju.
Yes, I'm sorry.
Yes, Ms. Dave. What do you want to?
I'm appearing in an IA 171-722 of 2019.
So what's the point? Tell us.
Well, the point that I'm making is, the permanent residentship, no one has talked about the rights of the women that were taken away. So the permanent residentship would not come to the women who have married outside the state of Jammu and Kashmir. So, my lords,
That was set aside. That was ultimately constitutionally.
yes, my lords, state of J&K versus, my lords, Dr. Sushila Sahani 2002 judgment. In fact, the full bench of the Jammu Kashmir High Court held that they will have permanent residentship even if they marry outside. But the state then, my lords, the learned AG there made a statement that they will not get, in fact, my lords, the right to employment, right to scholarship, as well as the right to hold immovable property was taken away if you marry to a person who is outside the state of Jammu and Kashmir.
Thank you.
Well,
Mr.
it's my written
Biju?
submissions.
Yes, we'll take.
I have.
What is your page of the written submissions?
I'll give it to the learned court master, my lords. We had submitted to the nodal council.
All right.
2 pages only, my lord.
Volume 3, right?
Yes, my lords. There's one,
Yes, Biju.
my lords. We have got these rights now after 2019. Can a writ petition filed under 32 take away fundamental rights given to the other citizens of the country, my lords? Is my respectful submission. I'm obliged, my lords.
Yes, Biju.
I'm appearing for my client who is a retired major. He dedicated his substantial time in the area in question, which is J&K. And my lords, my IAS 17100 of 2019 petition civil number 1082 of 2019, my lords. Kindly note this because my.
Biju, just make a point now.
Yes, my lords. 17100 of 2019 is WPC number.
We'll see that. You just make what.
Just what's the substance? What's the point on substance?
My point is this, my lords. Before that, my lord, page 5152 to 525 of volume 3, my written submissions, where I substantiate what are the ground realities, where I substantiate what was happening, as my lords already asked. My lords, what is after going again and again, 370 subarticle 3 provides so there is a special provision. And if it is non-functioning, then what is the way out?
This point has been argued.
What is it?
Come on now, tell us something.
What is the next remedy, my lords? My respectful submission, my lords, is extremely clear in the Constitution of India, Article 368(1). Then 2 is saying that, 368(2) says that if so and so articles or chapters, if you are going to touch, or if you are going to touch basic structural principle, then you have to have the ratification of the 50% of state governments. In that subclause 2, there is nothing to do with 370. So 368(1) is starting itself is, my lord, extremely important, that language, that notwithstanding anything contained in.
Well, thank you.
Notwithstanding
Thank you,
anything.
Biju, we got the point. We got the point. Thank you. Sir, there at the back.
One more.
Biju, there's somebody at the back from Srinagar, Jammu, who is.
This is one area, my lords. Then my respectful submission, my lords, what I did again and again, my lords, I was repeatedly reading my lord judgments from 1950 onwards, at least 5 judgments, which are constitutional judgments, saying that there is every power for Indian Parliament and the President of India.
Thank you.
That I, my lord, separately indicated in paragraph.
We'll see on. Yes. What is your point?
I'm grateful just for the time. Lords, I'm appearing in 108-743 of 2018, Lords. said there's an IA filed, my lords, by the Bar Association, High Court of JNK and Jammu. Now, my lords, I adopt, my lord, the submissions of the SG and everybody, my lord, who is supporting this, my lord, CEO. One submission, my lord, if the Honorable Court would permit me, is that whether, my lord, at this 76th year of our association with a country, a question mark, my lord, on our nationality also would not hit, my lord, in the extended interpretation of Article 21. If I would seek the Honorable Court's indulgence, my lord, that whether right to live with dignity, my lord, starting from Maneka Gandhi's 78, would also include, my lord, a right to have a nationality after having lived with the country and identified oneself with. So, my lord, we take pride in being Indians outside of India. But when it comes, my lord, within India, can there be somebody, my lord, allowed to raise a question mark on our nationality? Because, my lord, when I was, my lord, following this, my lord, debate on the VC from JNK, questions like referendum also, my lord, were addressed. Now, in this, my lord, 75th Golden Jubilee, which we say, if, my lord, at this point in time also, a question mark on our identity with a particular nation where we have contributed and will live with pride within India, if this is still, my lord, is hanging in balance, though, my lord, we owe our, my lord, gratitude to the Constitution that this debate is still permissible. But then, whether the Constitution, my lord, can be so flexible as to include a debate also as to a person who has contributed a lifetime. No, this is the third generation, my lord, into it. Now, from 47 onwards, we are now, my lord, in 2023. And in 2023, my lord, if I have to prove to somebody that I am an Indian, whether, my lord, my life is actually a life of dignity, is, my lord, my humble submission. I'll seek honorable bench, my lord, indulgence.
Thank you very much.
I'm grateful.
Thank you.
Lords, 35A is linked to Section 6 of the Constitution of Jammu and Kashmir and is linked to 370. If 272 and 273 is not upheld, what the consequence is that there is a tap on the application of the Constitution of India, including Part 3, which can be turned on, turned off at the discretion of the state government, which by itself is inherently discriminatory, abusive. Yes, which has been therefore, apart from IR Coelho, I think most important is Puttaswamy, where your lordships have upheld the socio-economic interpretation, because for a long time fundamental rights were essentially social in nature, but an economic angle has been brought about. Our problem is we are being deprived of that. One very brief point, my lords, the consistent position of Republic of India, and I deliberately say Republic of India, before the United Nations Security Council is that there was no sovereignty of any kind, slightest nature, residing with the state of Jammu and Kashmir, neither under international law nor under comparative constitutional law. For comparative constitutional law, there's an opinion of Dr. Ambedkar, which is in my submission, where he said why there is not even an iota of sovereignty with any princely state, including state of Jammu and Kashmir. In international law literature, it is very clear, settled position of customary international law, which was also taken by the Republic of India in the Security Council in MC Chagla's speech and also Krishna Menon's speech, very clearly spelled out that under international law, there's no possibility of any such constituent, which is an integral part of India, to have any sovereign right. So that is clear. So therefore, no question of Constituent Assembly or Maharaja having any sort of sovereign power. In fact, it was made expressly clear in the Security Council itself by both of them that aspect rests entirely with the Union. So what is being now called as residual sovereignty can't conceptually exist. It contradicts the very idea of sovereignty propounded by Bentham, or even by Max Huber. Therefore, sovereignty, there is only one sovereign. All that they can have is legislative competence, that is also to minimal extent. Apart from that, there was a major argument which was made that instrument of accession had to be approved by JK Constituent Assembly. It wasn't necessary. The only requirement was Section 6 of the Government of India Act. This was the consistent position again put forward by MC Chagla before the United Nations Security Council. Also under section, one very last point, India was the successor state which included princely states. That comes from section 311 of the Government of India Act. Therefore, by virtue of that, India, already a singular entity, where all sovereign authority rests with the union and the constituents don't have any other power. To use the phrase of Krishna Menon, they are sub-sovereign entities.
Advocate General,
And nothing
for
for
UT.
Yeah.
United Nations. This is past history. There is nothing pending in United Nations or any. It is our internal.
Yes, my lords. Yeah.
There are history.
Yes. Only thing I was saying, that's the position, that there's no such internal.
And, being the AG, first of all, I subscribe to the submissions made by attorney and solicitor general and my colleagues on this side. One aspect perhaps need to be brought, but the basic fundamental rights include the health also. And health generates from the health medical education. All judgments, whenever it would come, I am passing a judgment to Lordship just now. But kindly see the plight in J&K. Whenever it comes to the taking a health care, the point would be that we, because of 370, will not allow those benefits which are emanated from Article 21 to flow to J&K. Now I am passing the judgment of this Honorable Court. But whenever this issue comes, this is 1984, where they say yes, for the rest of the country, that sending 70% of seats and 30 for local is funded. But when it comes to J&K, even this Honorable Court says we'll wait till the time comes. How long will this medical facilities, which are, just have a look to these judgments. In this last paragraph, the court says, so far as J&K and Andhras are concerned, we are told that there are some constitutional provisions, and therefore we deal. The result was that for so many years, the erstwhile state of Jammu and Kashmir and now UT remained deprived of the basic fundamental rights, including the medical education. So let's just have a look to this.
We'll have a look at. Thank you, Mr. Advocate General. Thank you.
There's a short
All right,
Holding my-
everyone, 1 minute each. Yes.
Yes, my lords.
Just before I conclude, all speeches, because I know that time, all exercise about understanding and the literature. One word is very important. All leaders, including Mr. Sheikh Abdullah, in unequivocal terms said accession, not the aggression. In the parliament on 8 January 48, everywhere. No blood, even at this stage of 75 years, yet we have to define our relationship with it. But as Article 371, Part 3, they were discussed so. In all cases, we are the integral part of this great nation, Union of India. All argument to the contrary are too late in the day when the Constitution of India had all its place, and now it is only academic, otherwise we are a part of that. I'm grateful.
Thank you, Mr.
Lord, the short submission. This amendment A cannot be seen as a silo in light of the larger transformative nature of a constitution. 3 bullet points that come in it. The violation of rights of those who are persecuted is so extensive, my lords, that it has been recognized as a grave human right violation in 2019. A violation, my lords, which is considered an international crime in international law, therefore attracts customary international law and is a jus cogens norm. So therefore, my lords, when such an acknowledgement does come in, really a case for restorative and transitional justice does arise. So clearly, my lords, those who have been persecuted and they want to go home, it will have to happen that security is ascertained and restorative and transitional justice does arise. So fact-finding missions, truth commissions, transitional commissions, therefore become the norm. Unless and until, my lords, an amendment of this nature does not come in, that takes away the conditions of oppressions that were there and that ensured that they were not only persecuted but had an exodus in 89 and 90 is not taken away. This higher feature cannot really be attained, my lords. So therefore, my lords, I submit that this has to be seen holistically. And attributing of responsibility.
You can put it in your note. It's in your note.
Millards.
Now, I'll limit my intervention on just 2 aspects, Millards. One is the proviso under Article 3, Millards. The contention of the other side was that the requirement of taking the views of the state legislature is a condition precedent. My lords, as the learned Solicitor General has shown already that wherever Article 356 was invoked, this proviso to Article 3 was suspended. Secondly, my lords, the views of the state legislature under the proviso are not binding on the parliament. Your lordships have so held in Babulal Parate's case. Thirdly, my lords, Article 3 is a plenary power. So any interpretation, any construction cannot be given to the requirements of obtaining the views of the state legislature if it denudes from this plenary power. My lords, the second argument is The Rajagopal case, Karunanidhi's case, which was cited by the petitioners, is wholly inapplicable, my lords. That is a one-paragraph judgment, and the finding that is given in that judgment is that dissolution of state assembly will not be a ground to hold that the constitutional machinery has been broken down in the state. Rajagopal case relies on UNR Rao, which is delivered by the same bench of your lordships. In UNR Rao, the contention was that a writ of quo warranto was sought against the Prime Minister and her cabinet. The contention was that since the House of People has been dissolved, and since the cabinet is responsible to the House of People under Article 75(3), the President should dismiss the cabinet. Your lordships rejected this contention and said that Article 75(3) will only apply where the House is not dissolved or prorogued. So this case is wholly inapplicable. My lords, my note is on volume 6, PDF page 50. Kindly consider that. I'm grateful.
My IA is, my lords, 146764, my lords.
Yes, Mr. Bhushan, what do you have to say?
Yes, my lords. I have to say, or make only one summation that this temporariness and permanentness of Article 370 has to be looked through the prism of word further in the preamble of Jammu and Kashmir, read with Section 3 and 147 of Constitution of Jammu and Kashmir also. Even Constitution of Jammu and Kashmir has not given power to itself to amend Section 3, where it is said that it is and shall be the integral part of Jammu and Kashmir Constitution of India. And second is will of people. This was argued strenuously.
Lordship, I appear
Yes,
for,
Dr. Khanna.
Lordship, I appear for Youth for Kashmir, Pannu Kashmir. We were the people who were displaced in 1990s, whom I represent. Lordship, my first point of submission is when the instrument of accession was signed, that day it was complete and formal integration with India. And
That point has been made. What is the next point?
Lordship, the second point that I wanted to make, that because of 370, there was no economic integration with India. That was we were making. And the other point I wanted to make was regarding the women's right, which Ms. Pathak has made. And Lordship, the final point I want to make it till 2016, even transfer petitions could not be filed in this court under the regular provisions. We have to approach under 32 or in the other provisions.
Thank you. Yes, yes, sir. What do you have to say?
19618, my lord. In my matter, my lord, no counter, no students has been filed, my lord. I got a letter circulated on 27th July, my lord, saying therein that I shall be able to file for written submission only after hearing both the parties. Now I have may kindly be allowed to.
What? And what is that SLP?
118, my lord.
Filed by whom? Filed by whom actually? You are the SLP petitioner.
My lord.
What is the order that you are challenging?
My lord, I am challenging the order on the part by the High Court, my lord. I saw there, my lord, to declare Article 370 a left provision. Second, my lord, declare separate constitution for the J&K void ab initio.
That is yes, that is
My lord, that I am seeking permission. I am seeking permission to file written submission. In view of my letter, my lord, which I circulated on 27th July.
So we'll come back after.
Yeah, why, during recess, may I just
Going
file
through my
minutes,
lord.
my submission so that they are on record,
My lord, after going through my written submission, my
they are
lord.
longer than I have to reply, Malad, I have to reply. Put it down.
Longer than the main arguments.
I'm sorry?
You can open your submission. We'll see.
That's what I'm saying, Malad, that I will.
We'll hear you, Mr. Sibil. After lunch, we'll hear you.
In the meantime, I should be able to file, Malad.
They are longer than the main submission.
One second, you have filed hundreds of documents, I never objected, even my first submission, you never, what is all this?
At lunch. We'll
My
hear
lord,
you at lunch.
written submission may kindly permitted to
Well,
file,
yeah.
my lord.
Hello, check. Hello. Hello, check. Hello.
Sir, we are concluded now. Yes, Mr. Sibal. No, sir. Thank you. Sorry. Sorry, sir. We have.
Sorry.
Thank you. All right. Thank you. Thank you. Thank you. Selfie arose out. Thank you. Yes, Mr. Sibal.
Yes, please, Your Lordship.
What we have said has been said. The Chief Justice had to say has been said. We've heard both sides, I think, for 15 days, quite patiently. Maybe, not everybody can be heard in a situation like that. Don't try ever to browbeat the court. We will never try that with you. Either with the chief or with me, anybody will try that. Okay. Thank you.
Yes,
As you said, thank you. That's all.
Yes, Mr. Sibal.
Next, Mr. Sibal. Next matter.
Yes.
Yes, Mr. Sibal.
You're not appearing before a trial court. You're appearing before the Supreme Court. Yes, yes.
Allow me to argue, please.
Yes, Mr. Sibal.
No, Maharaj, at the outset, I wish to state, Maharaj, that this case has been argued at several levels. And Maharaj, most of them unsolicited, without reference to the arguments made by us. I don't think anybody on this side challenged the sovereignty of India. Nobody on this side challenged the sovereignty of India. I, Maharaj, at the outset stated that Jammu and Kashmir is an integral part of India.
They say your first petitioner has said something which are not in sync with.
I am not concerned with that. If the first petitioner has said something, if he has said it, in what circumstances he says it, is it recorded? You ask him for an affidavit. I have nothing to do with it. There are two. Hold on. Let's not take time on that. 1 second. Let's not take time on that. I am not standing for him for what he said if he said it. I am not here.
Mr. Sibal, do we take it that Mr. Lone, therefore, unconditionally accepts the sovereignty of India and that Jammu and Kashmir is an integral part
of it? He is a member of Parliament today. He has sworn to the Constitution of India. He is a citizen of India. How can he say otherwise? And if anybody has said it, Malad, I, at my level, deprecate it.
No, it is one thing for Mr. Sibal to deprecate.
Let's not go into an issue.
A litigant before your lordship.
Ask him to file an affidavit, then I have nothing to do with it.
No, but it's your client. You have to ask.
I don't know. You are making an allegation. I don't know.
Not support terrorism.
Let them reflect on it.
If you don't mind, take it on the pleadings. Ask him to file an affidavit. I may not appear for him. I don't know, Manoj. Why am I? What have I? I am not to answer what an allegation that is made.
Because Mr. Sibal, when he invokes the jurisdiction of our court under Article 32 of the Constitution, he therefore necessarily abides by and owes allegiance to the Constitution.
And he's a member of the Lok Sabha. He is sworn to the Constitution of India. He's a citizen of India.
One second, Mr. Sibal. But that's Filter, 1 second. That's a submission, Mr. Sibal. But we want to have it from him that he unconditionally accepts that Jammu and Kashmir is an integral part of India, and that he abides by and owes allegiance to the Constitution.
Of course, he has sworn to it.
Terrorism
became a member of the Lok Sabha. He swore to it.
Mr. Sibal, because then when you argue and you accept, as far as sovereignty is concerned, you accept the sovereignty of the,
of course.
Number one, the people of India. Number two, that JNK is an integral part of India. When you argue, your client says something outside the court, something different to it, there's contradiction. And probably then he's also accepting there was an issue and a problem which had to be dealt with.
If I start, Manoj, recounting.
No, I'm not saying that.
So
be clear on that.
Manoj, it will unnecessarily lead only, Manoj, to a media coverage. Let us not go that route. We are arguing a pure constitutional issue. Manoj, there is a speaker of the BJP who was present there when this allegedly happened. There are some people who asked him to say something which he did not say. Why do you want me to go into all this?
No, please go into it. I have no difficulty. Lord, there is
It
an
is not
affidavit.
part of the record. It has been withdrawn. It has been deleted from the record. It is said in the, yeah, what is all this? It was said in the assembly, the
Affidavit of Mr.
BJP
Jad says-
speaker was there. It was speaker not of his party. The BJP speaker was there. He was asked to say something which people ask other people to say on the streets of this country. Why do we want to go into this?
No, Lord, we would insist, Lord, you must go in.
Therefore, we accept.
Of course, but unconditionally.
We proceed on the basis that he's willing to file an affidavit before our court saying that, well, he owes allegiance like every other Indian citizen to the Constitution of India, and that Jammu and Kashmir is an integral part of the country.
First aspect, Lord, I'm sorry for the interruption. Another aspect, the affidavit mentions that in all public speeches of petitioner number 1, he supports separatist elements and other elements. Let him say he does not support secessionism and terrorism. No citizen of this country can have any objection in filing that affidavit.
There's another
I do
petitioner,
not
Justice
support terrorism
Masoodi.
and
There's
secessionism.
another petitioner, Justice Masoodi. Please allow me to argue.
No, that's
For Justice Masoodi.
that-
You want to take any action
that's
against the
very
gentleman, you
unfair.
take
That's
action.
unfair to us.
Please don't derail a pure legal submission.
We'll hear you for Mr. Lone as well. There's no difficulty.
He wants to have
He has come to our court. We are more than duty bound to hear his submissions, and we are in the course of hearing his submissions. All that we want to say is, like everyone else here, because we have had people from across the political spectrum in Jammu and Kashmir who have presented rival viewpoints before us, different perspectives, which is welcome. That's why we are here to resolve those issues. But all of them have come here in one spirit, which is that they abide by the integrity of
You cannot be a member of the Lok Sabha and be a member there without abiding by the Constitution and an oath of office that I abide by the Constitution of India. He has to take that oath because he enters the Lok Sabha, as we all do.
That's what.
And there's an affidavit filed there, Malaj. How can that be? But be that as it may, Malaj, I did not know of this fact till this morning. Somebody
Just
raised
ask
it,
him to
Malaj.
file a short affidavit before us, a one-page affidavit. That's all that is necessary.
Lord, we are given a copy to Mr. Sybil's client. Lord.
Give the affidavit. There is no question, Malaj. I would not stand here. If he doesn't give it, I would not stand here arguing for him.
So before we close the argument tomorrow, just ask him to file a one-page affidavit. That's all that we require.
Yes, Lord, and I would request Mr. Sybil to insist to his client that no citizen would have any objection in saying that I do not support terrorism and separatist activity. Let him say that, or say that I will not say this. Let it be clear.
What is all this?
Which he is supporting.
What is all this? Well, we will certainly, Malaj.
I'm sure Mr. Sybil will.
So we'll convey this to him and he will file a short affidavit.
Had I known this, I would have myself.
What affidavit?
Anyway,
Will you allow me?
tomorrow.
2:30. Half an hour is lost just on this.
Mr. Sybil, yes.
It's not just on this, Malad. It is a serious issue.
What is a serious
country
issue? But do you want me to say something that I shouldn't say in court?
Well, he wants his fundamental rights to be enforced in this.
There are everybody has fundamental rights in this country.
But you take a
including
contrary
including those who on the streets you vilify.
They are also wrong.
So then that's all right. Then you should apologize for them.
All right. Yes, Mr.
So let's not let me argue the case, please.
They are not
Mr. Solicitor,
Let me
I
argue
think-
the case, sir.
Mr. Solicitor, we have indicated to Mr.
Your
Sybil,
Lordship have
let him
indicated
now open
to
the
me.
argument.
I
Let him
made a
open the
commitment that there will be an
Yes, Mr.
affidavit.
Sybil, you open the argument. ma'am.
Yes, please. Malaj, this case has been argued at different levels. And Malaj, I was somewhat pained when one counsel argued that we respect the sentiments of the people of Jammu and Kashmir. But you must also respect our sentiments. Now, Malaj, I think that we cannot reduce this case to an emotive majoritarian interpretation of the Constitution of India. Whereas all residents in Jammu and Kashmir are citizens of India. They are as a part of India as anybody else. If historically there is an article of the Constitution that gives them certain rights, Mullahs, they are entitled to defend that as a matter of law.
Yes.
That those rights may be taken away, may not be taken away, constitutionally or without reference to the Constitution is another matter. But to say that you must respect our sentiments as if they are somebody else itself is creating a kind of chasm that shouldn't be created, especially in court. That's number one. Number two, Malaj, and I adopt Mr. Salve's argument, that we are concerned with the interpretation of 370. Read the text, understand the context, and interpret 370. I entirely agree with that. And that's exactly what I'm going to do before your lordships. Number 3, my lords. If you look at the history of India in that context, my lords, you will find that Jammu and Kashmir had no links with the rest of India, geographically. No links. No part of the territory of Jammu and Kashmir was linked to the rest of India. And the two principles on the basis of which accession had to take place was contiguity, have to be contiguous. That's how, my lords, states like Junagadh, Hyderabad, many other states which are internally, which were within India, could never accede to Pakistan because that principle could not be established. So you had to have contiguity, and you had to have population. These were the two principles. And the decision, the third, was to be taken by the ruler. These were the three principles on the basis of which accession took place. Actually, Jammu Kashmir was not contiguous to India.
How do you say that?
Because, it is Radcliffe. When he came and he made the award, he gave Gurdaspur to India. That's how we got contiguity. That's part of the Radcliffe Award. Of course, Radcliffe, when he came, knew nothing about India. So you might appreciate, what were the forces behind it. And Firozpur was a district connected to Gurdaspur, which had a Muslim majority population. Firozpur was also given to India. That established contiguity. That one historical fact, your lordships may know. It's part of the records, of the case. The second grave issue that was confronting India at that point in time was Greater Punjab was Muslim dominated. The bifurcated Punjab. The majority population was Muslim. If you gave Greater Punjab, or what was Punjab at that time, to Pakistan, their boundary would reach Delhi. Nobody could afford that. And if India got all of Punjab, our boundary would reach Lahore. Neither Pakistan would accept it, nor India would accept it. These are historical, this is a historical background in the context of which the fate of Jammu and Kashmir was to be decided. Note another fact. Jammu and Kashmir had a constitution, a detailed constitution of 1939, which had an administrative structure like any other democratic structure, except that the Praja Sabha was dominated by Dogras. In fact, all the nominees in the Praja Sabha were Dogras. Sheikh Abdullah, who had an egalitarian outlook, was dead against the ruler and therefore was imprisoned. There was a popular movement in Kashmir against Hari Singh. Sheikh Abdullah and Pandit Nehru were of the same bent of mind, because Pandit Nehru also showed utter distaste for the concept of rulership. In fact, it was Sardar Patel who said, we must honor our constitution. Nehru said, no, we shouldn't. We shouldn't give anything, no privy purses to the ruler. That's all a part of record of history. That's why when the invaders came into Jammu and Kashmir, Nehru said, release Sheikh Abdullah first. And he became the interim prime minister. He then was made a member of the Constituent Assembly of India, negotiate the terms of the details of the accession. And remember, the constitution of Jammu and Kashmir, like no other princely state in India, no other, I say, was drafted after 1950. And came into force, Maharaj, in 1956, 57. It was completed in 56, came into force in 1957. Only state, only princely state. That's one set of historical facts that your lordships must keep in mind. Second set, even more important. The Indian Independence Act was passed in Parliament in UK on the 18th of July, 1947. Originally, India was to be granted independence in May 1948. The date was preponed to 15th August 47. So after the Indian Independence Act was passed on 18th July, you had 12 plus 17 days to complete the process of signing 562, if at all, instruments of accession. On the 25th of July, note this date, that's why I said I needed to put it on record, because your lordships don't allow me. Because my learned friend Miller's filed 18 pages of written submissions and then 250 Millers. I tried to file 5 pages and I was told I cannot. But that doesn't matter. This is all part of the record I wanted to place, but it doesn't matter. I think your lordships should take it on record, but I leave it to your lordships. Anyway.
Is it the only thing that you want to file is now this 5-page submission?
No, that was originally which your lordship denied me at that time. But I'm going to
file now
because he has made some list of dates.
What do you want to file now?
Nothing, Manoj, just basically I have to meet the arguments.
Fair enough. But so long as what you're filing is not much more than what everybody has so far filed.
No, Manoj, why
we don't want to be confronted with a 300-page document.
Manoj, your lordships, I will not waste a minute of your lordship's time, Manoj.
So how big is it and what is it that you want to file?
38? 38 pages. There's nothing much.
All right. File the 38 pages. No difficulty.
Well, we've even taken note of your earlier 15 pages. But if we had permitted you to file, the whole sequence, whatever.
I'm not complaining it.
Everyone else would have then
I am-
followed. That's
I am
the.
the last one to complain. I never once raised the issue. But when I was told that I can't file.
No, Mr. Sibal, it was not meant for you, it was meant for everybody.
I
Trust.
know that.
So
But
don't take it
everybody filed.
that-
The problem is everybody filed. But neither, there's too
Sibal,
little time. I
ultimately,
want to
we
go.
took down the need of having to record in
That's
writing
correct,
what
that's-
we have argued. But now we've taken.
It's all
on
right,
this
no problem. So, Manas, the same. His list of dates, not mine. No. We have already added, your list of dates I've made a blue mark, is you have had these green and yellow and that. I just added a blue mark to your list of dates, that's all. Not my list
So
of dates.
their list of dates, as I recall, was about 110 pages.
10 pages. I've just added 5 pages to that, Manas, to give some correct date.
So the 115 includes the earlier 110.
That's right.
And 5 which you have added. Fair enough. That we don't mind. There's no difficulty. And you have followed the same format, track pages.
We are not.
We know what you have added.
It's in blue, Manas.
So long as otherwise, it becomes impossible when we are just to sit down and get
Manas, we must burden your lordships and therefore we did it that. Anyway, so let's Manas move on. So Manas on 25th.
So just a second. You're filing therefore your list of dates, which
Yeah.
are 100.
And my written submissions, Manas, in response.
The written submissions are 38 pages.
Yes.
So all that you are now filing.
There's an appendix,
one second.
appendix to it, Manas.
The total 67 pages. Submissions are 1 to 38. Annexures are 39 to 60.
That's only appendix, Manas. That's an appendix data, Manas. That's all, nothing more than that.
What is the nature of the
Data, for example, he said reservation didn't apply to Jammu Kashmir. So I'm saying it applies. This is the article. So these kind of things, Manas.
All right.
There, for example, no education. Actually, education in Jammu Kashmir is free up to university. Free education till university. In the constitution itself. Manas, these are facts which should have been stated by the other side. They say there's no official language. There was an official language.
You can file it because
Thank
we now, it's 5 pages, basically 5 pages of list of dates added on.
Yes.
And your submissions about 38 pages. So annexure is to explain what, according to you, has been made available or what is.
That's all. There's nothing more. And I want.
But in the same vein that you said, don't take into account what they have said on the, more, should we say, developmental aspects. We shouldn't take into account what you have said also on what is available.
Exactly.
To answer the core constitutional issue.
Exactly. That's why I never went into that.
Simple, when you say 5 pages on the lighter side, my court, at least when I used to say 5 pages, if somebody handed over 10 pages, I used to remove the last 5 pages and confine it to the first 5 pages.
Now, let us note another thing. On 25th of July, 1947, the Chamber of Princes met. This was. So, Manas, in the Chamber of Princes, Sardar Patel said, we will only have with us, that the union, communications, external affairs, and defense. You are autonomous for the rest. 25th of July. 25th of July. That's also part of the record that I've given you. Mountbatten said it in the on 5th of July, he had said it also. So, Manas, therefore, and that was the understanding with the princes. It will be a federal structure, communications, foreign affairs and defense will be the union, and the states will be autonomous. That's one part. The other part was, Manas, there were some princely states, Manas, one of them, The only property it had was a well. He was a prince of that well, Malas. He had no means of livelihood. They naturally, such small states had to join larger princely states. Kathiawar, Saurashtra. Saurashtra had incorporated 220 princely states within it. The whole process of 17 days was an entirely asymmetric process. Idea was to persuade all of them to please sign instruments of accession. Pepsu was one of them. Faridkot, Pepsu, all those. That was happening, Millets, with Sardar Patel and VP Menon and Mountbatten, who had personal relations with all the princes, which neither Sardar Patel had nor VP Menon had. Because then the Governor General Mountbatten was actually served in India for a long period of time, and each of these princely states had a resident. And they would be told that you only should spend 10% of your revenue of the state on yourself, the rest you should spend on the public, but most of them spend 80% on themselves. But ultimately, they all exceeded. They all signed instrument of accession by 15th of August. With a standstill agreement and nothing more. Some of them who merged into larger administrative units didn't have to do that, because then they were represented by the larger administrative units. So my learned friend, the solicitor, is right that many of them, princes, did not merge because they were merged with other larger administrative units. So it was an entirely asymmetric way of actually getting them all together in 17 days. It was a Herculean task. Ultimately, who stood out? Hyderabad, Junagadh, Kashmir, and Travancore. In fact, the first ruler to revolt was Travancore. Because of the advice of the Dewan Mullahs, who ultimately got attacked and was in hospital, and then they signed the instrument of accession. But that's just I know that. I don't want to take it. And Mullahs, now you were left with Junagadh, you were left with Hyderabad and Kashmir. And as far as Kashmir was concerned, your Lordship knows, the instrument of accession was signed subject to certain conditions. Many of the instruments of accession that were signed by with other princes had a provision that they can be a supplementary instrument of accession, but they cannot be unless I give consent. That is, the ruler gave consent. So some of them had supplementary, but this didn't happen in Jammu and Kashmir. The point that I'm making is, Mullahs, Jammu and Kashmir was the only state in India where a special dispensation was made, for reasons which were domestic and reasons that were international. Which is why this whole argument that there must be uniformity is completely bereft of the historical context. Now, principle was contiguity and population. Junagadh acceded to Pakistan. Acceded to Pakistan. Somnath temple was in Junagadh, very dear to all of us. So, Mullahs, having acceded to Pakistan, India wanted to invade and take over Junagadh. Mountbatten said, you can't do it. He has acceded to Pakistan. This is foreign territory for you. So ultimately, Mullahs, infiltrators were sent. And they took over and there was no resistance. Then negotiations took place and Pakistan agreed to a plebiscite, a referendum. knowing full well that such a referendum would happen in Kashmir also then. The same thing happened in Hyderabad. The ruler was Muslim. The people wanted to join India. But he did not join Pakistan. He wanted to be independent. He didn't accede to Pakistan. There was a general this happens nowadays also. There was a freelancer who promised the ruler of Hyderabad that I will get you arms, you give me so much money. So they piled up a lot of arms to resist any invasion. Ultimately, that man, Mr. Cotton, left him, and the invasion took place and be occupied. So you're left with Jammu and Kashmir. Jammu and Kashmir, the population was Hindu, was Muslim majority, and the ruler was Dogra. It is in this historical context that you must view what happened in Jammu and Kashmir was only to ensure that Jammu and Kashmir becomes an integral part of India. There can be no question about it. I'll come to that. Yes, I'll come to that. There can be no plebiscite in Jammu and Kashmir. That is our position. We stand with India. Now, Manas, having signed the instrument of accession by 15th of August and some of them standstill agreements, the question then was they had to merge because none of them had any administrative units in place. You had to have local self-government, and your lordship knows at that point in time, we wanted India to be a democratic nation. So then Sardar Patel and Menon persuaded all of them to please have merger agreements so that we can treat you in the same way as other provinces. So all of them signed merger agreements, not Jammu and Kashmir. Nor was Jammu and Kashmir asked to sign a merger agreement. Never.
How many merger agreements were there actually?
I'll give you the number, Manas. I think we have them. No, much less. Much less. I will give your lordship the number.
Because everybody who signed an instrument of accession didn't necessarily sign a merger, right?
No. Because what happened was, Manas, many of them
had formed unions with existing states
That's
like Kathiawar or Saurashtra.
That's right.
Pepsu.
That's right. You'll have that. Manas, that's not an issue. So, Manas, that didn't happen in Jammu and Kashmir. So when the infiltrators came, Manas, and he couldn't defend himself, and he went away from Srinagar, Manas, he ran away from Srinagar. And we helped him, Manas, by going there. The issue arose, we had no communication systems in place. No communication system in place, and we didn't know the topography. Our army, because we had never been there. The army represented that if you want to deal with the infiltrator, the source of it is Pakistan. So we'll have to target Pakistan, to which Mountbatten said that will declare war. If you do that, it will be war. You cannot be allowed to do that. So we were not allowed to do that. So the result was that in that situation, kindly remember, Referendum is not the only place that we're talking about in Jammu Kashmir. There should be no referendum. There can't be a referendum in any case. But referendum happened in the northwest provinces. We had the Congress government in the northwest frontier province. A referendum happened there and they went to Pakistan. Referendum happened in Junagadh. So it is not as if this was alien to the concept of how people express their wills. But in our case, what happened was the government of India said, let the Constituent Assembly, namely the people of Jammu and Kashmir, represented in the Constituent Assembly, express the will of the people. That's how 370 came in. There was no other way to express the will of the people, certainly not through a referendum. Nobody wanted it. Especially after the first year, because in 1953, Sheikh Abdullah was arrested by Nehru. Because he raised the slogan that we want to be autonomous. Sheikh Abdullah was arrested by Nehru himself. Nobody wanted a referendum. Nobody would have allowed a referendum. But the way out was, in that context, draft a provision in 370 by which the will of the people of Jammu and Kashmir can be expressed through the Constituent Assembly. That's the historical lay of the land, Mulaj, in the context of which you have to read Article 370 of the Constitution. Now, Mulaj, let me disabuse the lordships of some of the myths that have been portrayed here. Number one, that Parliament has plenary powers under 370. Just the contrary. The power of Parliament to make laws is limited by 370. Nobody's read it. Just look at 370 with me. Please read 370 with me.
I don't think there are limitations on Parliament's lawmaking power because...
No, not that.
Yeah.
I'm not saying that. I'm saying something different. Just read 370 with me. I'll read it with you. Yes. Notwithstanding anything in this Constitution, the provisions of 238 shall not apply, and the power of Parliament to make laws for the said state shall be limited.
What are you reading? Which?
Article 370.
270.
It is a limitation on the Parliament to make laws. Yes, 1B. Matters in the union list to matters in the state list, in the concurrent list. It stares you in the face, and you're talking about plenary power. Where is that plenary power? If you want to pass any law, or if you want to extend the provisions of the Constitution of India, forget about 371 B1 and 2. Look at D. If you want to extend the Constitution of India in respect of matters which are in the instrument of accession, outside of those matters, you have to consult, otherwise you have to take concurrence. And how does the President of India act? On the inner advice of the Council of Ministers. The President is not acting in his individual capacity. It is the Council of Ministers which will decide, not Parliament. The governor acts on the aid and advice of the Council of Ministers. It is the Council of Ministers at the other end which will decide, not the legislature. It was to ensure that there is slow integration of Jammu and Kashmir into India through a process that is easy, through a process that will allow the executives communicating with each other to make sure that the Constitution of India, as applied to the Constitution of Jammu and Kashmir, is put into effect. Which is why the CO in 52, in 54, that's the background. Once we decided on the list that this is the entry in the list on which a law can be made, and two executives agreed on it, a law is made and it will be applied. That's the procedure, Malaj. Nothing to do with how they have interpreted the Constitution. And that's how it happened all the time. Which is why, if your Lordships will remember at the outset, I said this is an exercise of executive power. It is not even exercise of legislative power. Far be it some quasi, some ancillary constituent power. Doesn't exist. I am asked this one question for which, Mulaj, if you have an answer, Mulaj, I certainly don't have an answer. Mulaj, throughout, Gopalaswamy Iyengar, who was part of the drafting committee and who introduced the bill, understood 370 as we have argued before your Lordships. Exactly that. From 1950 to 5th of August 2018, no member of parliament, no member of parliament, no individual in the public space said otherwise. Nobody said it. Every interpretation of the Constitution as reflected in the debates in the Legislative Assembly and in Parliament interpreted the Constitution as Iyengar interpreted it and as we have argued before your Lordships. There has never been a dissent. When the government of India files an affidavit in this court, it's the same thing, except they say that now through this process, we have substituted the Constituent Assembly with the Legislative Assembly. They have understood 370 in the same way. Now in the argument, not part of their affidavit, not part of their pleadings, they say, no, there is some plenary power. Your Lordships are not sitting here in an advisory capacity
to tell them as to what 370 means. We are, Mulaj, testing the action of the union.
We are not having some academic exercise of the interpretation of 370. We just to test CO 272 and 273. Whether it was rightly done or wrongly done. Maybe rightly done, maybe wrongly done, that your Lordships will decide. But it has nothing to do with any plenary power, nor is it the case of the union. Now, let's accept their argument. Let's see, test it, Mulaj, how it will be. They say, this is a plenary power. Forget the proviso because the Constituent Assembly is dead. There is no Constituent Assembly now. There is a Constitution of Jammu and Kashmir which is in place. And the argument is, now that it is dead, I can exercise that power and abrogate it. That's always been the position. What it means is, Mulaj, that the Constituent Assembly and the people of Jammu and Kashmir signed their death warrant on the day the Constitution was made and the Constituent Assembly was dissolved. On the next day, 370 could have been abrogated. Instead of 5th of August 2018, 19, they could have abrogated the next day. So they were signing their death warrant. that while we are there, you can't do anything about it. But the moment we have drafted the constitution of Jammu and Kashmir, then you can tomorrow just take away. Just abrogate 370.
Because can any constitutional court can ever interpret 370 in this fashion?
Did anybody even think about it, Mullah? That a constituent assembly drafting the constitution of Jammu and Kashmir, saying that we are an integral part of India, taking note of 370 in the manner in which it is to be integrated into India, will say to themselves that the day we are not in place, it will be abrogated because there's a plenary power superior in 370, which is not there in 370, but because we say so, and which is not even part of the counter affidavit of this. This is not even the case of the union. What are we? Wait, this is not some. I mean, this is not even. You look at it textually, you look at it contextually. There is no other conclusion you can come to. Now, your Lordship asked me several times and asked others also, what's the way out? That's not for your Lordships to decide. Your Lordships are not here to tell them what the way out is, or for us to tell them what the way out is. It's a political process. The way out is a political process or some other process. That's for them to decide. The way out is not this, that you do something consistent with the interpretation of 370 and you argue exactly something else, which has nothing to do with your own counter affidavit, and that's the union. How can they be allowed to do that, Minister? What does concurrence mean? It means consent, as your Lordship has been saying. If it requires the consent of the governor of the council, governor acting on the aid and advice of the Council of Ministers, where is that plenary power that we are talking about and reading in 370? And 370, sub-article 2 says that if an order is made, Mullah, between 1950 and 1951, when the Constituent Assembly was in place, the Constituent Assembly can reject it.
Sibyl, why does the proviso to clause 3 use the expression recommendation when two other provisions in the same article use the expression concurrence?
Yes, I'll give you your Lordship that.
B2 uses the expression concurrence, and the second proviso to D uses the expression concurrence.
Absolutely. In other words, Mullah, when it comes to applying the Constitution of India
to Jammu and Kashmir in respect of in matters which are not with reference to the lists, Mullah, you need the concurrence of the state government acting on the aid and advice of the Council of Ministers. Agrees, Mullah, with that there is no plenary power of Parliament. Concurrence means I can say no. Means an executive can say no.
What is proposed? Now, if you read 370, and I just answer my Lord's question, if you read 370, the President's still notification cannot be initiated. Because the expression in the proviso to 370 are two expressions, necessary and before. The timing is set before the President issues a notification, a recommendation has to come, and that is necessary. And the order in which is that the first recommendation will come, then you will pass an order. You can't reverse that process on a plain language, on a textual reading, which I said, Mullah, I accept what Mr. Salve said. Read the text and give the answer.
Sibyl, is it not conceivable? I mean, I'm just thinking aloud.
Yes, sure.
That so long as Article 370 operated, it provided modalities for the application of the lists, the entries in the three lists, consultation in one case and concurrence in the other.
Right.
So long as Article 370 operated, it provided for the application of the other provisions of the Constitution, subject again
Same to the same
consultation,
process.
Same formula, consultation and concurrence.
Absolutely.
You probably rightly said that the object was to bring about a slow integration.
That's correct, which I've been saying.
In achieving that slow integration, the Constitution framers provided for consultation, this whole formula of consultation and concurrence.
Absolutely.
Checks and balances at two levels of government, the union government and the government of the state. But significantly, the Constitution doesn't tell us what would happen after the Constitution of Jammu and Kashmir would be framed. It contains no express provision that that Constitution would then be embodied or incorporated in the Indian Constitution. Because the Indian Constitution, by all indicators, we've seen several indicators, was always to reign supreme. So when it came to abrogation, it left in 1950 the point of abrogation to the exercise of wise statesmanship. You just said a short while ago, why didn't they do it in 1950?
It's not a question to do it. They had the power to do it. I'm not on that.
You're right.
Yeah.
I mean, you're right. Why did they not do it? They had the power to do it. If they had the power to do it,
Because they never understood 370 in this fashion.
no, there is an alternate hypothesis. It was always presumed that allow 370 to work out, there should be an eventual process of integration. Let that integration take place over a period of time, during which you will have this twofold procedural check of consultation and concurrence. At what point of time the integration is deemed to be complete, or that Jammu and Kashmir is ripe for an integration with the rest of India in the full and true sense of the term, was not hedged in by the Constitution.
Well, I'm sorry, with the greatest
Is
respect.
that not a possible?
No, it's not. It's not. Mullah's on a plain reading of 370.
Because there are very significant silences in Article 370.
You don't need expression of interest in this fashion for the simple reason that that 373 itself gives you a clue as to what was the reason.
There are
behind.
not sufficient silences in Article 370 to lead to the conclusion that the framers, both when they were on that side in the state of Jammu and Kashmir and on this side in the Union of India, left it to wise acts of statesmanship in 1950.
I hope on both sides, Mullah.
Yes, of course.
This was a unilateral act, Mullah. This was not a wise act. It was a unilateral act.
Just one, taking on what Chief Justice just said.
Yes.
It's quite apparent at that time what was either happening with the rulers and integration into India, because that was the objective. And it was all a political move at that time. There were different views expressed even with regard to J&K. If one looks at the wording of the articles, the argument of the other side was it was deliberately left very flexible and to some extent contradictory.
Yes. Mullah, I don't see the flexibility here. Mullah, neither I see the contradiction. Just read 3 with me, Mullah. If you find, Mullah, that there's a silence there about what would happen, Mullah, certainly.
And except for the provision for permanent residence, Section 6, which finds its mirror image in Article 35A, every other provision
Was really a mirror image of the Indian Constitution. So what is that an indicator of?
That's an indicator of the fact that
whatever is happening there is really the incorporation or the adoption of what is happening in the.
I can only say this to your lordship. I can only say
of the Union of India.
I can only say this to your lordship. Either we interpret 370 sub-article 3 in its text and context, or we find something that's not there. And as a matter of constitutional law, you have to interpret the Constitution, not find a silence in the Constitution to interpret something that is expressed.
Just read it, Manoj. Notwithstanding anything in the foregoing provisions of this article, the President may, now who is the President? Acting on the aid and advice of Council of Ministers, may by public notification declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify.
Now just pause here. Supposing, Millets, he was not to abrogate.
Is only to modify or apply with exceptions. Is that also unilateral power? Forget about abrogation for the moment. We have to interpret constitutional provisions as we read them, not as we find some element of silence which is not there. Provided that the recommendation of the Constitution, this is a proviso, that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary. That means to start the initiating of the process, that recommendation is necessary. And before the President issues the notification. It's a double emphasis of how that power can be exercised, not by Parliament, but on the aid and advice of the government. So, I
will of course have to then, to accept your argument, we will have to read a further condition in the proviso that the recommendation of the Constituent Assembly has to be in the same terms of the action which is proposed to be taken by the President. Namely, either that if you are abrogating, there must be a recommendation that yes, abrogate.
Yes.
Or if you are making 370 applicable subject to such changes,
yes, same thing.
Then the recommendation must be also along the same.
Yes, yes, absolutely.
But that's not there in the proviso, isn't it?
It is, Malaj. It is before any of this. Kindly see, provided that the recommendation of the referred to in clause 2 shall be necessary.
This is a core argument on which you have taken one stand, the other side is taken
what we have
another
to-
stand. We'll have to.
No, all I'm saying, Malaj, at the moment is, Malaj,
What their stand is that proviso will not evaporate and write off the third clause of Article 370 after the Constituent Assembly as.
Malaj, at least
That's
so
their
far,
stand.
so
Your stand
far,
is to the contrary.
so far, Malaj, I can only go by precedent. So far, the proviso has never been interpreted in the fashion that they are seeking to interpret. In any judgment of the Supreme Court since
That
1950.
occasion never arose. Probably.
That's not the way they acted. Malaj, kindly please appreciate what they've done.
Therefore, according to you then, if the proviso cannot be applied because the Constituent Assembly has come to an end.
No, Malaj, with respect I say, that's not the point.
Because the proviso says the Constituent Assembly referred to in clause 2.
Correct.
So it is only one Constituent Assembly which was formed for the purpose of the framing of the Constitution of J&K.
Correct.
Even if you have another Constituent Assembly in J&K, you can never have that Constituent Assembly which was for forming the Constitution.
No, Malaj, let me answer.
Therefore, the proviso cannot apply at all.
Let me answer it.
In your submission?
Yes. My answer is the following. When the Constitution of India was framed in 26th of January 1950, there was no Constituent Assembly and there was no Legislative Assembly. So what did Malaj, the Constitution makers, provide for in the proviso? They envisaged that there would be a Constituent Assembly. Envisaged that there would be a legislature. If there was a Constituent Assembly which would abrogate 370, there would be no Jammu and Kashmir legislation. Constitution. There would be no Jammu and Kashmir Constitution. Because that's abrogation. Constituent Assembly would recommend abrogation. At that point in time, those who drafted the Constitution were not aware as to what was going to happen. That's why Sorry. I'm sorry.
370 in the slide, there are two arguments. One, obviously, with reference that the proviso will not be controlling the main part of 3. That's core dispute between them.
That's right.
Provision will not be applicable is contradiction in terms.
Now, Malad, let's put it differently. Malad, this whole process was a political process. What Salve argued, Council argued, there is a political compromise. So you pull the plug anytime you want to pull the plug. At least 370 doesn't allow you to do that, but assume that's the case. If it's a political compromise, there will be a political solution. Why are lordships finding some constitutional solution that doesn't fit into this? That's not what your law, Malad. You have to, please look at it this way, Malad. If the process was political, the solution has to be political. Now, how that solution comes about is not neither for your lordships, not for us to Malad suggest. This is something that they have to do in collaboration.
The initial part was political, now it has to be constitutional.
No, Malad, if that is so, Malad, if now it's constitutional, then that means that the
While
Constituent
keeping in
Assembly.
mind, while
Just look at it
keeping in
this
mind the fact that the intent behind the article was temporary and transitory in nature.
But that I'll come to a little later, but Malad, the answer to the question is that the Constituent Assembly was framing the constitution of Jammu and Kashmir, knew that after that task was over, it would end, and was signing a death warrant under 370 sub-article 3 that now you can abrogate the constitution. Well, that can't, I'm sorry, Malad, on a plain reading of 370, I have the greatest respect for your lordship.
Therefore, the sequitur of your submission on the proviso to clause 3 is that once the Constituent Assembly has formulated the constitution of J&K, which has been adopted,
yes,
the proviso ceases to have any existence.
Yes, and 370 ceases to have effect.
Therefore, 370
ceases to have effect. 3 has ceases to have effect.
Sorry, 370 or
sub-article 3 ceases to have.
Therefore, 370
Yes.
bracket 3 ceases to have effect.
Yes.
In which case, 370 by itself, apart from 370 clause 3, assumes a permanent character.
It's permanent in the sense that, Malad, what is left of this autonomy that we are talking about? If the argument is it is just a shell, what is it that you are trying to do? What is the argument today, Malad? I've heard it, Malad, several times over. What is left is only a shell. Everything is already there.
That there's a contradiction in their argument.
Well, I'm only saying, Malad.
Just one. There's a contradiction in the argument. They said that main substantial part of the constitution, including 356, is now fully applicable. But what was the main stumbling block was section 6 and 35.
But as far as 35 is concerned, that's a separate issue.
No, I'm not interpreting.
Complete adoption of the Indian Constitution in toto, in completely as in case of other states.
Strike down 35A. Well, I don't understand where we are getting here. If this is the only stumbling block, you strike down 35A.
That's the judicial way.
No, that can't be politically done in any case. Because there can be reasonable restrictions and there can be classifications in terms of Article 14. It has happened in Uttarakhand, it has happened in Himachal, it has happened in other states, Malaj. No, it can't happen in Kashmir. Malaj, it is happening in Assam. You are fixing a date to people who came into Assam.
We'll come to that a little later.
I'm only trying to indicate, show the mirror to myself that if it happens in Kashmir.
There's actually, I feel, the two spectrums which have to be decided.
Yeah.
When you use the word temporary, whether it's actually temporary in the sense they understand it, or it is temporary in the sense you understand it, that it was with the context of the Constituent Assembly. One. Number two, how you understand subclause 3 is that once the Constituent Assembly dissolves itself, 370 in the form it exists according to you is frozen in time for all times to come. Correct? This is what your argument is.
No, 370 sub-article 3, Malas. The rest of it is still remaining.
Yes, I'm saying 370, the remaining part is frozen as period of time because of the historical perspective.
No, not remaining, Malas. You can continue to integrate. 3 is frozen.
3 goes to
Absolutely.
remaining part subsidy.
Yeah, absolutely.
They say no, 373 is not limited to that stage because of the manner COs have been issued and can extinguish themselves.
That
This is a
COs have been
fundamental
issued in not in under 3.
Then comes the methodology, whether they could have done it or not. That's
Well, the COs have not been issued under 3. This is the problem, Maharaj. These COs can continue to be issued. All of them are under 1. So, and Maharaj, I'm sorry to say this, when you talk of temporary provisions, it is not a temporary provision. Kindly
Mr.
look at-
Tibble, ultimately, therefore, it will boil down to this, that there is in our constitution, if we accept your submission, there is in our constitution a provision to which even the amending power, which is available in respect of the rest of the constitution, is unavailable.
It's unavailable because it's been amended. 368 has been amended with a proviso.
And there is, in that sense, a provision of the constitution which lies even above the basic structure of the constitution.
No, Maharaj, I mean, why do your
Because you
lordship say
cannot,
it is?
370 you can't amend also.
I'm sorry.
You can't amend 370 also.
It's not
To amend 370, you have to take the route of 368, and 368 takes you back to 371 by the proviso. Therefore, we would be then really accepting a situation. We're not saying it's unstateable. We are testing the proposition. Is there a part of the constitution? The only restriction we have found so far in our jurisprudence on the power of changing, altering the constitution is a basic feature doctrine. We are now going to add one more, which is that Article 370 lay even beyond Article 368, and much beyond the basic structure doctrine, because you can't touch Article 370. It assumes a character of permanence.
Well, this is getting more interesting. This is even getting more interesting. Well, let me now ask myself a question. Supposing I were to file a petition tomorrow in this court that the proviso to 368 is unconstitutional. 368 too. Supposing I were to file the petition, and what my lord is saying is upheld, is right. That how can you do that? Strike down the proviso to 368 and amend it under 368. There are hundreds of ways of doing the same thing, Manoj, but we are testing the proposition in the context of what they have done.
The postulate that a judicial, in the exercise of judicial review,
what your lordships are putting to me.
We must take the proviso as a given.
But I am saying, yes, Manoj, it's your lordships who are saying there's something silent in it, which I don't see, Manoj. I don't see the silence in that proviso where the perpetuity of a presidential notification can be issued at any time, even after Manoj, even.
Because the two plain consequences of your submission are, first, once 370 clause 3 goes out of operation for all intents and purposes, 371 and 2 have a permanent character in the constitution.
2 is not there, Manoj. 2 is not there.
Right, 2 is, of course, yes, after the constitution. 371 has a permanent character in the
That's
constitution. Second, you cannot amend 370 using the 368 power because of the restraint which is imposed by the proviso, which again takes you back to 370. Therefore, even the power to amend 370 is within the fold of 370 and not 368.
Let me answer that also, straight away, Manoj.
So we are carving out really a position of provision of the constitution which lies even higher than the basic features doctrine.
No, Manoj,
Isn't
that
the
your
place
lordship should not say, Manoj, because that's not yet tested. That your lordship should not say, that's not tested yet, whether it's higher than the basic feature of the constitution or not, Manoj. But kindly see, this was added in the 1954 order, Manoj. Proviso to 368(2) was brought in by the order, as well as, Manoj, the proviso to Article 3 in 1954. Who brought it, Manoj? The government of India. State of Jammu Kashmir did not. They gave its consent to it. Why did they do it? Because they did not want 370 to be tampered with. I'm not saying this, Manoj. I am talking of the intent of the government of India. And the proviso was added both to 3 and 368. Not my intent, And your lordships are now saying, what is the intent of the government of India? It was made clear that even under 368, you can't do this. Government is a continuum. Kindly, Millers, appreciate that. It is not something that was done by Jammu Kashmir on their own. I understand, Millers, and there we go into the sentiment argument, the emotive argument. The argument that Mr. Dwivedi made, with respect. That we appreciate the sentiments of people of Jammu and Kashmir, but there are sentiments in India. Whereas with the greatest respect, I humbly pray that we are dealing with the Constitution. It's a sentimental thing. I also have sentiments with a lot of things. But when we come to court, we discard do away with what our heart, the nature of our heartbeat, and come to brass tacks rather than interpret the Constitution. You can pepper it with emotive instincts, Millers, but you can't get away from the plain language. And my respectful summation to your lordships is a political process must have a political solution. And as I said, what is left of 370? There is no residuary power with the, we talk about residuary. What is the residuary power? There's no residuary power with the state. When did the state ever exercise residuary power? So for all intents and purposes, it is fully integrated.
In other words, according to you, there is no solution to Kashmir within the Constitution. Devise a solution outside the Constitution.
Now your lordships are putting this to me.
Ultimately, that's not what I've argued. That's the hypothesis, that the solution has to be political outside the Constitution.
It is a problem looking for a solution, and your lordships don't have to provide that solution, is what I'm saying.
All solutions have to be within the framework of a Constitution.
It is within the framework, Mothers. It is within the, who says it's not within the framework? Well, isn't 370 a classic form of federalism? Unlinked to the federalism that we practice? It's a classic form of federalism. There's nothing unconstitutional about it.
There can be a lot of arguments on the other side. Let's not go into all that.
No, I'm just saying.
I'm
saying, Millers, it is not unheard of. It is not something that is so utterly unthinkable
that a state can have a certain special status.
If you go by Dr. Ambedkar's adoption speech, it's quite clear that he wanted a unitary form, primarily unitary form with certain federal features.
It is unitary, Millers. Who says it is not
That's
unitary?
very clear, and there's historical reasons. And let's not go into the
Ambedkar said an also very important thing. Where Jammu and Kashmir, he said that. Say something. Just come to my mind, Millers. I've skipped it. No. That's not what he said. That equality is in your mind. The equality, all people in this country are equal. Some are not considered equal. That's all. That applies not just to Jammu and Kashmir, that applies to a lot of places in India. So let's not go that route. Well, just because it's a union doesn't mean we are not federal. We are a quasi-federation is what we are. And that's what Ambedkar said, that we're a quasi-federation. But Millers, quite apart from that, that's how all members of parliament since 1950 have understood it. Millers, why are we? That's not their case. We are trying to find a solution, which is not the case of the Union of India.
Dr. Ambedkar in his speech, both speeches, 4th of November 1948, as well as 25th of November 1949, he has distinguished the American Federation with our federal structure, and he has specifically stated that in America, there is a citizenship of the Federation as well as the state citizenship, and it permits two constitutions, the state constitution as well as the federal constitution.
Correct.
But in India, we adopted a single constitution and single citizen.
Absolutely, right, Manoj, but kindly look at it this way. It is this Constituent Assembly that approved 370.
Which Ambedkar ji was a part.
So therefore, the question will be whether it was a temporary measure.
No, this is what the Constituent Assembly said. This is what Manoj, the cabinet said. This is what the government said. This is what the government has been interpreting 370. This is what they have done, Manoj, in the light of the interpretation of 370, as we have placed it before your lordships. What is 272? To replace the Constituent Assembly with the Legislative Assembly.
That is trying to implement the proviso, no? They've used the proviso. Now they are arguing just to the contrary. How can your lordships even allow them to do that? We are testing, we are testing the process.
We're not testing the power. We're testing the process. And the process adopted by them is the 370 sub-article 3 process. They have substituted Constituent Assembly to Legislative Assembly. Then they have imposed 356 and Parliament has become the Legislative Assembly and given consent to itself. Plenary power or any silence in 370 which allows them to do what they wanted to do. That's not their case. So we are now adjudicating a case which they have not pleaded before your lordships. If some private citizen were to do that, would your lordship ever allow it?
So, Mr. Sibal, you are saying 373 doesn't exist practically. Correct? That's your argument. Their argument is 373 exists and we've taken that.
No, they say 370.
That's the second part. Whether the process applied by them under 373, if it exists, is the proper process as per 373 or not, is the second limb of the...
But I'm saying something else to your lordships. They proceed on the basis that 370 exists.
Correct.
Therefore, they are not saying that 370 doesn't exist after the Constituent Assembly was drafted and nothing else happened and there's no Constituent Assembly. It's not their case. We are now, we are now adjudicating upon a case which is not the case of the Union of India before your lordships.
Many things have been said, Mr. Sibal, from both sides, which are really not, in our view, prima facie germane to the main issue is this of 370. As you say, one side of the argument that with the Constituent Assembly going away, 373 really did not subsist, only 371 survives. Their view is that 373 subsists and that's the route we have adopted. Second limb arises if 373 exists and the route they have adopted, what's the correct route, permissible or not?
But that's what I'm arguing. When I opened, I only argued on the route. If your lordships remember, I never went into any political argument, any historical context.
So that is your argument. That
I never talked about lack of sovereignty. I never talked about federalism. I never talked of any of that. I said this is the process they have adopted and this process is unconstitutional.
I remember you also said that it's not for us to, or for you, or to suggest what is the alternative.
Exactly.
Then when an alternative route is followed, it will be tested in its own way.
Correct.
This is the route they have adopted.
And
they have not taken a 368 route. They have taken
correct.
a 373 route.
So the first question that your lordships have to answer is 272 valid or not?
And that we have to decide.
Yes, and that can't be decided. That can't be decided because that they have followed the route of 370 proviso, Manoj. It is their case.
Yes, yes.
So the problem there with the argument is that 370 can't be decided in the context of the argument now raised. That after the Constituent Assembly is not there, we can do what we like. But that's not what their case before the court is. Their case is that they have applied the proviso and substituted Constituent Assembly for Legislative Assembly.
That's what the CO says.
That's right. So you have to test only that, which is what I argued. I didn't argue anything else.
We are not asking you to argue beyond it.
No, they have forced me to argue beyond it. They have forced me to argue beyond it. But let me go back
Even
a little.
assuming that they have followed the route of the proviso to 373, I don't think we can prevent them from sustaining the exercise of power on the ground that even independent of that we are entitled to.
That's not in their counter.
I'm sorry, Manoj, that's not their case.
Just my.
Oh, I'm sorry, you read your counter.
It's a sweet.
me as to what they say.
They meant 367.
No, Malas, in exercise of the powers under clause 1 of 370.
Absolutely.
So, Malas, they are saying that, and then they say the proviso.
That was for incorporating the proviso.
But I'm only saying that they are.
Sorry, 367 to the, that was for amendment to the 350.
That's what I'm saying.
But ultimately then they invoke the power under 370 clause 3.
With the proviso, Malas.
Yes, with the proviso.
But that's all I'm saying, Malas. I'm saying nothing more than that. That's the
We have understood your argument on that.
Yeah, I'm just saying, Malas.
In fact, we had put that question to the Attorney General also.
You also given the answer, Mullah. This is a sui generis provision of the Constitution, must be interpreted in its own terms. That's all that I'm saying, Mullah. And kindly like a counter.
This part, I think we've conceptualized, we've put our doubts to you, you've conceptualized. your
Giving
answer.
life to 373 through Article 367. That's their counter. That's all that we are testing, Mullah. Okay, so, Mullah, that's done. That's done, Mullah. That's done with that. Now, Mullah, kindly go back to. No. Now kindly go back to the list of dates, and just orally, Mullah, I'll mention to your lordships. 20th of June.
2018. Well, that's 19th of June, BJP withdrew support. 20th of June, Governor Amarat puts the assembly in suspended animation.
Now, the latter part, now you are going into the.
I'm going to test 356.
356.
356. Right. And the dissolution of the assembly on 19th of December,
On 21st of November 2018.
Now, Malaj, the normal process is, Malaj, for the governor has the power to keep the assembly under suspended animation without the aid and advice of the Council of Ministers. That power is given under 92 of the Jammu Kashmir Constitution.